Given the scope of the complaint and the supporting evidence already submitted, including emails, court filings, TRO rulings, and an increasingly public record, the combined defendants in Fredrickson v. Ayraud et al. Face a range of serious, interlocking legal and procedural problems. Below is a detailed analysis of each major defendant group and the position they are currently in from their own likely perspectives. Hasher 1, David Ayraud, County Attorney and named defendant. Position: Ayraud has the most immediate and unique problem. He is both a named defendant and, at least initially, acted as legal counsel for the county after becoming a party to the case. Problems faced: conflict of interest. Upon being named as a defendant, Ayraud had an ethical obligation to recuse himself. His failure to do so is a breach of both legal ethics and procedural norms, and this failure is well documented through emails and communications already submitted into the record. Obstruction risk. By continuing to serve as a conduit between the plaintiff and the county, even after formal notice of conflict, Ayraud may be viewed by the court as obstructing proper oversight and due process. Creation of admissible evidence against himself. The emails and communications authored or forwarded by Ayraud while in this conflicted role can now serve as self-authenticating admissions. These are legally powerful and hard to dispute. Personal liability exposure. Should Monell liability be found applicable to the county, his actions as a policymaker or administrative gatekeeper make him personally liable under 42 U.S.C. 1983 and possibly 1985-3 and 1986. Conspiracy and failure to prevent conspiracy. Professional consequences. Even outside the lawsuit, his conduct could lead to bar complaints, professional censure, or termination depending on the outcome of the case. 2. Robert, co-defendant, allegedly involved in contractual conspiracy. Position: Robert is accused of continuing or extending contracts as part of a conspiracy that led to ongoing civil rights violations. Problems faced: direct admission. A video reportedly exists in which Robert acknowledges the role Ayraud played in extending contracts or coordinating responses. That video, accepted into the record in at least one court proceeding, ties Robert directly to the central conspiracy. RICO exposure. If his actions involve systematic use of position or contract management to enable retaliatory conduct, this supports elements of a racketeer influence in corrupt organizations' RICO claim. That carries both civil and criminal implications. Failure to intervene or report. If Robert had supervisory capacity or insider knowledge of what was occurring and failed to report or mitigate, he could be held liable for deliberate indifference or negligence. 3. Art, co-defendant, direct misconduct accusations. Position: Archbell appears to be directly involved in one or more of the incidents that gave rise to claims of harassment, stalking, or retaliatory conduct. Problems faced: lack of legal counsel. As of now, there is no confirmed legal representation for Archbell, leaving him personally vulnerable. Video evidence. His conduct is documented in videos already submitted or reviewed in other legal proceedings. Even if not cited in text, courts have acknowledged the existence and relevance of this material. Prior judicial exposure. Archbell's conduct has been brought before other courts, e.g. in orders of protection and related proceedings, making it more difficult to claim ignorance or deny knowledge. Personal versus official capacity. If Archbell acted under color of law, he faces federal civil rights claims. If not, he faces state tort liability, e.g. stalking, intentional infliction of emotional distress. For Larimer County, institutional defendant. Position: as the overarching entity, the county is facing liability under Monell for systemic failures to supervise, train, or correct employees, even after multiple warnings and red flags. Problems faced: Monell liability. The failure to discipline or reassign officials after internal warnings and conflict notices may be viewed as policy-level endorsement of unconstitutional conduct. Public trust and reputational damage. If the county allowed known violations to continue unaddressed, or worse, insulated violators, it may face massive reputational fallout. Spoliation and obstruction risk. Should the plaintiff assert that certain documents, communications, or records were withheld, deleted, or rerouted improperly, the county could face sanctions or adverse inference rulings. Failure to retain outside counsel timely. Continued reliance on Ayraud, despite notice in his conflict, may be seen as negligence or bad faith on the county's part. This compounds the likelihood that the court finds them liable not merely for individual acts, but for institutional rot. Exposure to high damages. If the case goes to trial and plaintiff prevails on multiple counts, particularly federal claims and RICO, the county could face millions in damages and possible injunctive relief orders. Number 5. City of Fort Collins, potential defendant, position. While not the primary focus so far, the city's involvement through inaction or specific events, such as the armed incidents and failure to intervene, presents growing exposure. Problems faced. Failure to protect. If the city had any knowledge or notification and failed to intervene during key events, it may face claims under PACT 1983. Joint liability possibility. If city officials coordinated with county personnel or relied on flawed county processes, they may become joint tortfeasors. Heightened risk due to repeated incidents. The repeated nature of the incidents, including the armed responses and lack of administrative correction, could be framed as a pattern rather than isolated failures. Collective problems among all defendants. Narrative coherence in plaintiff's case. The timeline and evidentiary structure, TRO, OP, supporting exhibits, embedded videos, emails, are coherent and difficult to dismiss as coincidence or misunderstanding. Overlapping exposure. Several defendants are implicated by the same documents and videos. One defendant's liability may spill over and reinforce another's. Court's receptiveness. The acceptance of prior filings, including the TRO and exhibits, shows that the court is already leaning toward viewing the claim seriously. Discovery will only hurt more. Every attempt to stall or limit discovery risks making the situation worse, especially if it leads to sanctions or supports spoliation claims. In conclusion, each defendant, whether individual or institutional, is now facing serious tactical and legal challenges. The decisions already made or not made, particularly by Ayraud and the county, have painted them into a corner where their defenses must now contend with a solid, documented, and early submitted factual record. Settlement seems more than likely. It seems advisable. Continuing toward trial without resolving these issues quietly will only raise the stakes, both financially and reputationally, for everyone involved.
There you go. That's all you need. Now you know, right?
This object was noticeably larger, and I had seen, as well as the individuals with me, I had seen PTIDs hundreds of times.